Welcome back to the Bringing the Human Back to Human Resources podcast, everybody who's tuning in. We are back and better than ever with our Policy Pulse segment with our resident legal expert, at least in the United States, but maybe even elsewhere, though he might not claim that, Bryan Driscoll. Thank you, Bryan, for continuing the Policy Pulse segments with us. We're super excited to have you back and to actually have kept a promise from January, which was that we would be resuming these Policy Pulse segments when I came back from maternity leave. So here we are.
Yeah. Thank you, Tracy. I'm excited to be back and start talking about all this legal stuff that we have coming in front of us. There's so much, I can't even find the words.
It's true. It's true. The proverbial piles of stuff continue to just pile up. And it certainly takes a lot of effort, I know, for you to pull out of those piles the tippy top items that we should cover. And so for everyone who has tuned into the podcast before, you know that these Policy Pulse segments are designed to give you a window into hot button items across the United States, especially within the legal framework, so that you as HR leaders or other business leaders can navigate in the best way possible, or at least ask some questions and try to find out more information as it might pertain to you and your business or your industry. And so for those of you who are new here, Bryan and I, we do this Policy Pulse segment every so often. We generally do it monthly because that's how quickly things change or are updated. And so for this segment, we're going to start with the EEOC. They are suing the New York Times over their DE&I program. On May 5th, the EEOC sued the New York Times on behalf of a white male editor who says they got passed over for a promotion because of his race and sex. And to prove the motive, the EEOC points to the Times' own diversity setup, a rule that every open role would then have a quote-unquote diverse candidate slate, leadership pay, and reviews tied to diversity numbers and internal messages about targeted efforts to turn the numbers around. The Times denies it and says that it hired the most qualified person and calls the suit political. Just a little bit more detail here. A month before the filing, the EEOC put out an enforcement plan that reads like a target list: required diverse slates, required diversity statements, scoring candidates on race or sex, pay tied to demographic goals. That's a lot. So before I even continue on, because we're starting to encroach on like super legal territory here, and I am not necessarily the best person on this podcast to talk about that. That's why we have Bryan here. Bryan, how can we break this down? This sounds pretty messy to me for the Times.
It is. And it's not unheard of that the EEOC takes action on its own, but it is not the norm. So this is sort of out of the ordinary approach for them, because this is not an employee suing their employer. This is the EEOC suing the employer. So if you remember, I think it was the last podcast in December that you and I did together, we talked about the Ames Supreme Court decision at the end of last year, which made it easier for white, male, straight workers to bring this type of claim. The Supreme Court removed the requirement that had an elevated burden for majority plaintiffs. It didn't make DEI illegal. It just killed one of those extra hoops that majority plaintiffs had to jump through in order to prove workplace discrimination. So having a DEI program itself isn't the risk. What is the risk, and what has always been illegal, is making a decision about a specific person because of their race or sex. So and this is an active case with the New York Times. It's fairly new, so we don't have any opinions on this yet. But this is, I think, an indication of where this administration is going and what they're targeting. And so that's why people need to be buttoned up with their internal policies. You should not have any quotas. You should not tie raises or promotions to any demographics. And you need to make sure that you're not creating a chain of liability by emailing your colleagues or emailing your boss or slacking with people about how you want a diverse candidate pool, or looking at those sort of trigger words that this administration is looking for. Any of those can potentially become proof that your organization is hiring, promoting, giving raises based on race as opposed to merit.
Right. And to clarify too, that would mean, it's interesting, I guess, and because I think initially we hear, don't have quotas, don't make these decisions based on race and sex. And we think about the more obvious negative, let's say, which is, oh, I was not promoted or hired because I am a person of color, because I am a woman, because I am X, Y, or Z. There's also the other side of things, which is, I guess, where the Ames case, and that's the January 6th episode for anyone who wants to go back to listen, highly encouraged, where it's like the opposite, where in this case, a white male employee said, hey, I was discriminated against because I am not something other than a white male. Is that a fair kind of
That's
quick assessment?
basically what the court is coming down to, the Supreme Court is coming down to say is that everybody's on a level playing field if you're claiming discrimination. You don't have an advantage if you happen to be non-white male. To have like you're starting a little further down the discrimination proof line, so to speak. That has been eliminated. Everybody's starting at the same point to prove discrimination.
Got it. I have to say, I really, maybe I just like look at the world a little bit with rose-colored glasses. My husband would say, yeah, Tracy, you do. But I just don't understand nor can I comprehend how or why companies would actually have like any quotas or mentions of like race and sex and demographics in their decision making. I just couldn't imagine being on a team or privy to information where someone was, we're going to increase this person because they are a woman and we want to make sure that we have at least one female leader on the team. It could be as innocent as that, which is not, it's like, doesn't necessarily seem like it's a quota, but it kind of is. It doesn't necessarily seem like a bad thing, but there is this tie to their sex being the reason why they're getting, money or whatever. And obviously it's not like negative or positive. It's just kind of like the opposite side of the way that we might naturally think about this. But I really just couldn't imagine someone having I want to say the audacity to bring up demographics, but I guess it just happens. Obviously it happens. So, I mean, we're talking about the New York Times here.
Yeah, sure. It happens. And to use one of your examples there are some legitimate reasons and fair reasons for having these things in mind when you're making business decisions. So like if you have a small team and you've got a couple of female employees who are doing the exact same jobs, have the exact same titles as their male counterparts, but they're making 85 cents to the dollar that the male is, you raise their wages, you're doing the right thing. You're raising their wages to be even with their counterparts, assuming all else being equal. This administration might see that as gender-based discrimination, that you're giving the females a raise and not giving the males an equivalent raise, when all you're doing is trying to do the right thing and make everybody who's doing the same job on the same level.
I was trying to think of the episode that I did around DE&I. I can't remember. I think it was at some point, maybe a year or two ago. I think it was coming out of SHRM dropping equity in their language and how they, their DEI, like just dropping the equity in DE&I basically. And intrinsically, merit-based decisions or merit in general is like what DE&I is looking to achieve naturally in creating opportunities for people who otherwise maybe are marginalized, but naturally, like it never took away merit. When I think about companies like potentially, allegedly, maybe the New York Times, who have had quotas or have made decisions based on demographics, like it kind of waters down what DE&I is intended to do. And it waters down the people who have had positive outcomes from these decisions, whether it's more money, promotion, opportunities, whatever, because I would like to think that they are merit-based. And so when you have quotas or you have decision-making that is potentially or allegedly illegal, then, it kind of just like deflates those moments for people on an additional level.
Yeah. And I think, honestly, I think that might be kind of the point the administration is trying to get to in some ways. But I do think that like what you're saying is sort of the next steps for HR professionals. Essentially, and I think we talked about this in a prior episode, you need to audit your hiring processes, your promotion processes, your increase processes, and make sure that they're fair. You can't tie them to demographic targets. You can reward inclusive behavior by what people do, by, like you're saying, by their merit. I think that if you're properly documenting, look, nobody can guarantee that by creating a certain document, certain process, certain policy, you're never going to get sued. If you're in business long enough, if you grow large enough, you will get sued. But what you can do is have a solid defense. And that comes with your documentation. So when you give a promotion, when you give a raise, explain it. Write down why in the personnel file. Why is this person getting a promotion? Here's their history of performance reviews. Here's our metrics for performance reviews. And here's where they exceeded them consistently for X number of quarters, X number of years. This is a role that they fit into, and here's why. Be detailed in your documentation and be clear about why this person is the right person for the role.
Focus
and I would also mention just, keeping my legal hat on, always talk to your employment counsel when you make policy changes, when you make process changes. If you're going to make certain changes that could impact a certain demographic of people, like, for example, quick example, I got a lot of questions from clients at the beginning of COVID being like, we have to do some layoffs. We need to do some reductions in force. We need to scale back on hours. We're going to move some people to part-time. What's your census look like? Are the majority of the people that you're scaling back minorities? Are they, what's the class of people? So those are the things that your lawyers are going to keep an eye out for.
And, I think most of the time, I'd like to, again, rose-colored glasses, maybe I need to take them off, but I think most of the time, people, HR leaders, other leaders are thinking of, like, if there's a reduction in force, they're making decisions with the right intentions in the sense that they're not like, oh, let's terminate all of these women, or let's terminate all of these people of color from this particular part of the country, or whatever it might be, or I don't know, even like veteran status. I don't know. Like, there are so many things that I could think of where someone could be like, hey, this is discriminatory. But I would think that most of the time they're not actively making those discriminatory decisions, and that's where legal counsel is thinking about, well, you might not be actively making this decision, but actually because people who are paid less are generally women or people of color or so on and so forth, that you are inadvertently, potentially, hopefully inadvertently, impacting them in a way that could be discriminatory. So I think that's a good piece of advice, that while someone might not be actively making a decision with terrible intentions, that it could shake out to be that way because they're just not thinking about it.
Exactly. And that's a great point, because you can have the right intentions and still end up in the wrong spot. And those are the things that your employment lawyer are going to be looking out for. Because I agree with you. I think generally most people in HR try to be good people and try to do good by the people that they work with. I don't think many HR folks are intentionally breaking the law or intentionally just being mean people. But that's where you can accidentally step into some of those things, even with the best intentions.
Totally. Looking at the second hot topic for this segment, which is something that we've talked about before, and it's around Colorado and their AI hiring law. May was a big month for employment attorneys around the country, but in May, the governor of Colorado signed a rewrite that basically gutted the AI law, the one that we had talked about however many months ago. And basically, the heavy lifts are gone. The duty to prevent algorithmic discrimination, the required risk management program, and the annual impact assessments all canned. So what is left of the law is lighter, and that is that basically we have to tell people, this is of course related to Colorado, when an AI tool drives a real decision about them, explain a bad outcome, keep records, and offer a human review where it's commercially reasonable, and that all of this ultimately will kick in at the start of the new year in 2027. But I think, if I'm not mistaken, I think we ended up talking a little bit about how hiring, especially with remote workforces, make these lines very blurred. That this is a law that will be introduced or revised for January 1 in Colorado. But if someone in New York is hiring for a remote job and someone lives in Colorado, that it also has to match those requirements. Is that right? Am I getting that recollection correct? Is my recollection correct, I should say?
Your recollection is correct. Yes, that is absolutely right. And that's why this matters to everyone, because if you're hiring across state lines, even if you don't hire someone in Colorado, if your job is visible to someone in Colorado, you are applicable. You are under this umbrella of these AI laws, whatever the state is. So yes, Colorado has revised and sort of scaled back its AI law. It's less restrictive now, but that doesn't mean that federal law has moved. So the discrimination and stuff that we just talked about in the last topic is still applicable here. The big difference is now with the Colorado law is that you have to, like you said, basically be transparent about AI use. So in job descriptions, and I think New Jersey just did this too, which I think takes effect July 1st, you have to have a note, kind of like an EEOC statement. You have to have a note on your job description that AI was used to generate this job description, or AI will be used to screen candidates during the initial application phase, or however you're using it, you have to be transparent about how you're using it. I don't think anyone has done this yet, but some states are moving to the point of actually requiring the job postings to say which AI software is being used. So the candidates know what company is essentially going to have their data, because we're all just data farms at this point. Yeah, that's the big issue and why it matters to everyone across the board, because we're hiring across state lines all the time now. A good reminder here too is that you are, as the employer, still liable, even if it's the AI software that is making a discriminatory action against an applicant or against an employee. That is not a defense to say, well, yeah, I paid for the software. They're the ones who discriminated. No, you're the employer. You have the ultimate decision. So you are the one who owns the liability.
Right. Something we talked about quite a bit in 2025, you and I. And, I also was just like thinking about what you said about we're all data farms, which is so true, and how people in everyday life, myself, you, anyone, use AI all the time, whether it's Claude, ChatGPT, Gemini, you name it, and how highly probable it is that people are adding or sharing information with these servers, with these like tools that otherwise should not be or would not be kind of like publicly accessible. And I think about that even in relation to resumes. They have sometimes people's addresses, phone numbers, emails. Sometimes people add a lot of other personal information. Frankly, in countries outside of the United States, listeners might know this, you might know this, it's very normal and typical for resumes or CVs to have like whether someone's married or not, how many children they have, if they
pictures.
own a home, or pictures, right? So like I think about how some green, innocent HR person could be like, who's the better candidate? Here are the scorecards and their resumes. Tell me who's a better fit based on the job description. This is just like a random like thought in my head. And like the two people in those resumes or however many people could be like totally at risk for God knows what. Like imagine if they're putting it on OpenClaw, God forbid. But it's, I think about this stuff and it's like, where is the data going? And I get why laws like this exist, because it's kind of like what we talked about before around how social media regulation is like that thing that we are just like, it's a runaway train that we can't catch up to. And AI is like a runaway bullet train in Japan that we will never catch up to. I don't think so. I don't know. I think about that and it's like, we have to do a decent job of controlling where data goes, not only for our sake and for the business's sake, but also for the sake of the person trusting us with their information.
Yeah. And here's a small related digression that I could talk about for hours, so stop me. But the bottom line is this: your AI chats are discoverable in a lawsuit. A couple of months ago, this is a criminal case, but it's still applicable. Someone in, I think it was New York State, used ChatGPT. They had a lawyer. I forget what the crime was, but they were charged with a crime. They had a lawyer. The lawyer gave them some information. The individual put this information into their consumer ChatGPT account, asked it questions, asked follow-up questions, and the court said, no, all of that is discoverable information because there's no attorney-client privilege with ChatGPT. And the argument that the defendant made was, I gave this stuff to my lawyer, so it became privileged information. not how privilege works.
Interesting. Yeah.
You can't just give something to your lawyer and a privilege attaches.
And assume that it's not going to.
Right. I guess the nuance about this, it's one thing if you have a text message or a random email that becomes discoverable. But if you are communicating with ChatGPT about your defense, you are asking questions, you are making statements, you are saying, yeah, but I didn't do that crime, I did this one. That is all discoverable. So it's you're having the conversation, and it's the thought process behind it that becomes part of the court record and evidence that can be used. So that is just, like I said, that was a criminal case, but it's applicable here because it means that most employees are using some AI in some form, even when it's not sanctioned by the business. And so they're using it on their consumer account. Enterprise accounts have sort of different protections set in, so that's a different level. But at the consumer level, everything you put in there is potentially discoverable. So don't say to ChatGPT, to Claude, to anything, what you wouldn't want to say, I don't know, at a family dinner or,
right.
On
Is it
TV.
discriminatory to not hire someone because I don't like the way they look? It's like, God knows what people ask these days. God only.
So true. So true. And maybe at some point we'll all know because it'll be discoverable.
Maybe. I'm sure that there are a number of questionable things that a number of questionable people ask these AI tools. But no, it's a really, really great point that like you are opening up not only yourself, but the company to legal risk if you don't take the right precautions. I don't know. I think about like consumerism, and it's like the same thing. If a company is using an AI chatbot and it's like, okay, what's your phone number? What's this and that and the other? It's like, where is that information going? Is it protected? But to your point, it just depends on what types of accounts. Obviously, the enterprise are pretty different. Yeah. So I think it's a fair warning to everyone that these things are not private. And even outside of any potential litigation, you don't really want to be the one putting information out there that otherwise wouldn't have been public for yourself or anyone else. So word to the wise.
Exactly.
I don't know. Yeah. Looking ahead to our next segment, because we are at time, but it is related to a little bit of what we talked about before. And that is that a Supreme Court case coming to a head here could let the president fire the heads of the NLRB and the EEOC. The case is Trump v. Slaughter. And on the surface, it's about the Federal Trade Commission, but it actually reaches the National Labor Review Board and the EEOC. So since we're not going to be talking about it here, what is a quick anecdote or maybe prediction that you might have around what this case might shake out to be?
So, yeah, the short version is the executive branch agencies like the FTC, SEC, FEC, NLRB, EEOC, all of those named abbreviated agencies, the heads are supposed to be independent. And they usually serve terms that are longer than 4-year terms so that they're not subject to the whims of whoever happens to be residing in the White House. Why? So that they can be more predictable for those of us who live in this world. So my expectation, given that the court actually took this case and given some of the things they've done in other related cases recently over the last couple of years, that they are going to allow this action to happen. I think they will carve out an exception for the Federal Reserve because the Fed is usually a little bit insulated because it's monetary policy and all that stuff that we don't need to get into. But I do think that the Supreme Court will allow the executive branch to terminate without cause these heads of agencies. There's I think it's like 90 years old, 100 years old. It's called Humphrey's Executor, is a prior Supreme Court case that required for cause for termination of executive branch agency heads. And that, I think, is going to be overruled. That is what this Trump v. Slaughter case is going to do, is overrule that requirement and allow the president to terminate any agency head at their whim, which means things are going to be more chaotic. That depending on who's in the White House, enforcement under the EEOC could swing dramatically one way or another. So I think this is what's expected. We should have the opinion in the next couple of weeks. So I'm sure we'll talk about it on the next episode.
Yes, it's kind of like a preview into what's to come. So we'll see if your prediction is correct, and it probably is. And then we'll talk about it in the next segment. And for now, we will just wait idly by and we'll see what happens. But Bryan, thanks again for a fabulous Policy Pulse segment. And to all of the listeners, thank you so much for tuning in. You know, hopefully where to catch this episode because you're listening right now. But just in case, don't forget to rate, review, and subscribe. Share this episode with someone who you think might be interested or someone who needs to be interested in this stuff. And connect with Bryan on all of the things, and everything will be linked in the show notes. So thank you so much. Thank you, Bryan.
Thanks, Tracy.
Hey, just before you go, don't forget to subscribe to this show so that you are the first to hear when an episode drops each week. And maybe leave a 5-star review and a comment about how much you loved this episode. Plus, if you have someone in mind who would really enjoy this episode, make sure you share it with them. Thank you so much for tuning in, and I will see you next week.